Hey, welcome everybody to the Scales of Injustice. I appreciate everyone being here. I'm, as usual, just going to give it a little bit of time for people to get in here. I'm sure everyone will be shocked that I actually started on time. We all know that doesn't happen often. Hi everyone. Let's see who I got here. Sapricop and Susan and Jack. Thanks everybody for joining in. Appreciate it. I have 14 people, so got a few going here. I meant to close my door, so I hope Justice doesn't start barking. She's going to. I mean, we all know she's going to, but I'm hoping not. Hi, Stacy. Hi, Darkside. Thanks, everybody, again, for coming and joining me on a Friday night. Sorry, again, I could not do it yesterday. I'm actually questionable tonight, to be honest. I was going through the petition, and this thing is 30 pages, and I was riding the struggle bus so hard trying to get through this. My brain is just not right. It's been bad for the last few days, and it just really showed when I was trying to read yesterday. I would reread it and reread, and I just couldn't comprehend what I was reading. I really struggled through it. Today I actually slept. I knew I was tired. I slept about 8.5 hours, and I thought that'll be great. No, my body is still just like rebelling against me big time. It just does not want to cooperate. And my brain is still only at about 50% right now. It was only about 10% yesterday. It's about 50 today. But I was going through the petition, and I was itching so bad to want to do what I used to do, where I wanted to look up all the case law and kind of, see how good it was. Like basically, have trouble coming with words still. So sorry, but essentially, like how good the citations were and if there was anything wrong with, that's what I like to do. I like to pick things apart and to kind of guess what the state's going to say and try to guess what the court's going to say. And I think I got through about 2 sightings, and I was like, screw this. I can't do this anymore. My brain does not want to do this anymore. So I did a little bit, but then for the most part, I just read it just so I could get through it. And I did take some notes, so hopefully I got something to say that people will find of interest. I know that there were actually a lot of people that did videos yesterday, so that's kind of good because then I didn't feel so bad about not going live yesterday. Hi, Alice. Who else just came in? Baby's Red. Jen. Thanks. And then coincidentally, this afternoon, about noon, all of a sudden my phone rang, and it was Steve. And I was surprised because I haven't talked to him in a while. I talked to him about a month ago when I was at Sandy's house, and he called and I talked to him. And we're good. We're fine. But we just don't talk very much. And so he called, and that just was really nice to hear from him. It was really nice to hear from him because I know I was very worried about him. I've been very worried about him, about his state of mind, his mental health, especially after his mom died, but then getting the adverse decision from the Court of Appeals. I was very, very concerned for him. Hi, David. Hi, Ronald. See people still coming in. So it was really good to hear from him. And the first thing he asked was how I was doing. And I kind of guessed, and then Sandy told me later that she did mention to him that I wasn't feeling well yesterday. So he called just to see how I was doing. So as much as, people want to think badly about Steve, and even I'm hard on Steve a lot, he actually can be very sweet when he wants to be. And so it was really nice for him just to call to check up on me because he was concerned how I was doing. It's crazy. But to my surprise and to my great joy, he was actually really good. He is in great spirits, the best I've heard him in a long time. And he is very hopeful. And it's not that he's even just like hopeful. He said flat out, I'm getting out of here. Plain and simple. Okay, I'm getting out of here. That's it. And so he's not, I said, he's not just like sort of hopeful. I mean, he's convinced that it's just going to be a matter of time. He said, and I said, yeah, this is just a speed bump. And he said, oh, I've been over bigger bumps than this. This is nothing compared to what I've been through. I'm like, okay, good job. I was so proud of him for just being so optimistic and so feeling so hopeful. And he obviously talked to me a little bit about what's going on, but not much. He can't say much over the phone or anything. But Kathleen will be filing a petition with the state court if this does not succeed, and I think that's not a secret. Everybody kind of knew that at this point. And so he was in really good spirits. I asked him if I should pass along any messages, and he just said, "Tell everyone hi. I hope they're doing good." Again, he's like wants to make sure everybody else is doing good. He's hopefully there'll be good news soon, and he wanted me to say that he loved everybody. Tell you he loves everyone. So that was basically it from Steve. And we talked for a half hour, but it goes by so fast. And I'm sorry if I'm talking really fast. You know me, I always do. Yeah, the mental aspect. Jack saying that for him, where did it go? That was not here. Glad to hear though. I'm glad I put that up, Stacy. For him, the mental aspect has to be the most difficult, and that's what I was very concerned about. I know the loss of his mom was brutal, devastating. And then getting the ruling from the Court of Appeals denying his petition just so soon after that, I was very concerned about his mental well-being. But boy, he said he's actually been in a good mood the last few days. And so he was, I said that was probably one of the most upbeat I've ever heard him, actually. And so even though I'm not feeling well, it really made me kind of lifted my spirits too. Just hearing from him and knowing that he's doing good. He's still stuck in his cell a lot. There's the visiting is different now. They have to set appointments, and it's only a 90-minute visit, whereas he used to have 3-hour visits. And now, like I said, you have to actually call him, or I don't know how you do it, but you have to set up an appointment to go visit, and you have to wear masks and everything. So it's different, but at least he's getting some visits now, so that's good. Other than that, he's still in his cell most of the time, but he's okay. Steve is okay being alone. He's used to it. He likes it. He actually prefers to be alone, I think. People that have jobs are able to leave their cells, but he's not working right now, so he's in his cell most of the time. He said he's on the phone all the time, which is typical of Steve. So, oh gosh, I didn't even have my microphone up. Can you guys hear me? Gosh, I didn't even have my microphone in front of me. Could you hear me? Nobody was saying they couldn't hear me, so hopefully it was picking it up. I told you, brain's not all here. Yeah, he definitely feels his mom. He got it's hard for him to talk to his dad because his dad can't hear. But he said he did get a letter from his dad, so he was happy about that. He said he hasn't had a chance to write back yet, but he's going to. He said his hand hurts from writing. Okay, the microphone's kind of sensitive. Oh, okay. Is there still an echo, David? I'm so sorry. I'm just a disaster all the time. Well, hopefully it's better. Okay, so let's get to this. Now, the first thing I wanted to talk about was what a petition for review is. And again, I know most of you probably already know this stuff, but I'm still going to go over it for those that don't. Now, you can really compare this to what happened with Brendan's case in the federal court. It's very similar. Obviously, the cases are different, but when you're talking about petitioning for the Supreme Court, the standard is very similar. Okay, thanks, Jen. They do not retry a case. They are only concerned with matters of law, and that's it. Whether they're errors in law that were made by the Court of Appeals. Okay. And I actually just put up made some notes on the actual state statute. Supreme Court review is a matter of judicial discretion. It's not of right. Not everybody is entitled to judicial review by the Supreme Court. Again, same as federal court. It will only be granted when special and important reasons are presented. And Kathleen actually relies a lot on that. She brings that up in the petition. And then they give some examples of what their role is. And they will hear a case when the case calls for the application of a new doctrine, whether it be, here, I'll just read it. The case calls for the application of a new doctrine rather than merely the application of well-settled principles to the factual situation, or the question, I knew she'd start barking, the question presented is a novel one, the resolution of which have statewide impact. I can't read, sorry.
The question presented is not factual in nature, but rather is a question of law of the type that is likely to recur unless resolved by the Supreme Court. So all that is saying is basically that if there's any type of discrepancy in case law, if you have cases where there are two cases that, or this case has a ruling that's adverse to what happened in a previous case using the same case law, they will have to settle that. If it's something that they think is important for the judicial process statewide overall, they'll listen to a case. And sometimes they'll listen to a case if they just think that the law is not well defined, if they think that more explanation is needed with regards to whatever case law they're talking about or statute that they're talking about. You're welcome. Thanks. Okay. Someone said thank you. Again, it says Facebook user. Just saying, if you're on Facebook and you haven't given StreamYard permission, it won't tell me who you are. So thank you, but I don't know who you are. Let's see. Okay, so it says that the petitions will be considered if there is a real and significant question of federal or state constitutional law is presented. The petition for review demonstrates a need for the Supreme Court to consider establishing, implementing, or changing a policy within its authority. I already covered the other one. The Court of Appeals decision is in conflict with controlling opinions on the United States Supreme Court or the Supreme Court or other Court of Appeals. The Court of Appeals decision is in accord with opinions of the Supreme Court or the Court of Appeals, but due to the passage of time or changing circumstances, such opinions are ripe for reexamination. That's what we were hoping for Brendan's case. If everybody remembers, we were hoping that they had said they hadn't taken a case on a juvenile false confession in 50 years. And they were hoping that enough time had passed that they would, and enough social evidence had, is clear now proving that, false confessions happen, that they would hear the case, but they didn't. But that's one of the reasons they're supposed to hear it. And they did not. I know that one of the most important questions people want to know is, can the state respond? Yes, they can. They have 14 days. I believe on the docket, it actually says September 9th. That is the 14 days. That's why that date is on the docket. It's there. September 9th is the date that they have to file a response. And of course they will. I don't see any reason why they wouldn't. I mean, who knows with them, but I would think that they would. And there they will just tell them essentially why they think that the Court of Appeals decision is correct, why they think that they shouldn't overturn it. Just, the usual reasons. And if they grant it, then what happens next is usually they will ask each party to submit briefs, adding more detail to their. Oh, actually, this would probably be considered the brief. I think that they can submit some supplemental briefs. Again, brain shot. But they can only file briefs based on what the court has allowed them to present under review. She's essentially asking for three claims that she's asking for a review on. And if they only decide one of them is what they're going to review, then that's all they have to stick to. They can't do anything about the other two. And then I will talk about what happens after this, after I talk about the petition itself. And already I'm so tongue-tied. I'm sorry. It's in my head. I'm trying to get this out. I'm exhausted. Okay, so some of the things that she talked about, the first thing was the cumulative effect of ineffective assistance of counsel, IAC, as I will say from now on, because that's a mouthful. One of the cases that we talked about a lot, and when I say we, me, I did a video on it when I talked about the IAC claims. It was one that I said was really important to Steve's case, was State versus Thiel. I talked about it a lot. And the reason why it was so important was because it established the fact that when you're determining a claim of IAC, that they can be cumulative. The claims can be cumulative. I can't even talk. Cumulative. You can have a bunch of separate IAC claims, but that doesn't mean that they should be decided individually whether they could possibly lead to a different verdict, whether they could prejudice a jury. You have to take them all as one and look at them as a whole and say, if you put all of these claims together, is that enough that it could have prejudiced the jury? Okay. And that's exactly what the Court of Appeals did not do. They took them one by one. And so this whole section is essentially KZ telling them that you have set the bar too high because nobody else has to do that. Nobody else has to count their claims individually. And so that's why she's saying that Steve is having to do something that nobody else should have to do or has to do. And so she's saying under State versus Thiel, where it is supposed to be a cumulative effect, why did they judge them separately? Because that's not the standard. Now, she also said Wisconsin cases have found ineffective assistance for failure to hire experts. So that was the big thing she was kind of counting on there. Now, she cited State versus Zimmerman, and this is one of the cases that I actually did look up. Now, in Zimmerman, this is what they held in Zimmerman. We conclude that Zimmerman's trial counsel was deficient due to his failures to present the DNA evidence that excluded Zimmerman, offer alternative medical testimony, and challenge Renee's, somebody in the case, hypnotically refreshed testimony. Yes, there's hypnosis involved. Further, we determined that the cumulative effect of these errors was prejudicial, and therefore Zimmerman is entitled to a new trial because he received ineffective assistance of trial counsel. Now, one of the big things in this one is that when they say that there was a failure to present DNA evidence, that alone is actually pretty huge in this case. In Zimmerman, there were actually DNA results that excluded Zimmerman from being the contributor. And these were cigarette butts that were found and hairs that were found near the crime scene, from what I can remember. I didn't read it real closely. And they excluded him. During the trial, the experts said that they were inconclusive, and the defense attorneys didn't challenge that. So again, when you're citing case law, you have to make sure that your case law is, pretty on the nose. And they did say, in addition to that, they did say that they should have been allowed to enter this alternative medical testimony. If they would have hired a medical expert, in this case, the competing medical expert, meaning Zimmerman's expert, was actually Jeffrey Jansen. And you should all know who that is. He's the medical examiner from Milwaukee County. And he was actually helping the defendant in this case. He's the one that was the expert that they called post-conviction, that basically said that the medical examiner or whoever testified during the original trial was an idiot and his conclusions were all wrong. So they did rule on the DNA issue that alone was enough to be prejudicial, but they also ruled that not hiring a medical expert was also enough to be prejudicial. And they actually decided that this hypnosis testimony, whatever, also was prejudicial. So they actually won on all three of them. So yeah, they didn't actually need all of them, but they actually won on all of them. So I just wanted to point out, when they talk about the cumulative effect, in this case, they didn't actually need all of them, but they did say though, that taken as a whole, they definitely were prejudicial to the jury. So that's what that case says. If that helps at all, or if anybody found that interesting. That's Sue saying hi to Justice. Hi, Sue. She'll say hi back. My little barker. Oh, who said, oh, my hair looks amazing. It's actually kind of flat right now, but funny thing about the hair. I was lazy, and when I air dry my hair, it is this bad combination between wave and frizz, and it's just terrible. And so really quick, I actually just did a curling iron really quick because I wasn't going to fight against my my crazy waves with a straightener. So that's why I actually have curly hair right now. Okay, so we're going to move on here. And then we're going to talk about, again, still in this category, she cites Strickland again, and then she cites Thiel. And she says that to show prejudice, the defendant must demonstrate that there is a reasonable probability, but for counsel's unprofessional errors, the result of the proceeding would have been different. And this, again, is when she's talking about that maybe each individual claim might not rise to that level, but when you look at them as a whole, you have to say that they definitely should have undermined confidence in the verdict. And that's actually in the next part, when she's quoting State versus Thiel. It says a reasonable probability is a probability sufficient to undermine confidence in the outcome. When a defendant alleges multiple deficiencies by trial counsel, prejudice should be assessed based on the cumulative effect of these deficiencies. That's exactly what State versus Thiel says. Now, this is one other thing that they said in Zimmerman, which could be something that the state uses. We'll see. The court noted that the evidence against Zimmerman, while sufficient to allow a jury to reach a verdict, was far from overwhelming. Counsel's deficiencies relate to evidence that, if properly challenged, could have reasonably called Zimmerman's guilt into question. And unfortunately, this is something that is going to be something the state is probably going to try to leverage. I try to think of the word when they filed. They're going to say that in Zimmerman's case, the reason why they said that the new evidence was enough to undermine the confidence in the verdict, it was because that the court is saying that it was already really a close call whether they had enough evidence to convict him to begin with. In Steve's case, they're always going to say that the evidence was overwhelming, because they always say that it was overwhelming. So therefore, you need a lot to undermine confidence in that verdict, which obviously none of us agree with that and know it's completely not accurate, but that's how a court's going to look at it. So I just want everybody to keep that in mind, and we'll see what the state says when that time comes. I can't remember why I took notes on certain things. So she's, another thing she really focused on was the fact that the Court of Appeals is acting like Steve has already had a hearing because of the way they were evaluating the facts and the evidence. Now, I'm just going to read some of this here again. It improperly weighed the evidence Mr. Avery's new experts would have used to rebut the state's case, as a circuit court is tasked with, and then it ruled as if Mr. Avery had an evidentiary hearing and failed. The court unreasonably determined the facts pertaining to the blood, bullet, bones that would have been prevented if it had a transcript to review of an evidentiary hearing. A court of appeals is certainly not qualified to act as an expert on scientific evidence. Okay, so let me see that. The court required Mr. Avery's new experts to state in their findings the ultimate legal conclusion that Mr. Avery was framed, which is ironic considering that the trial court did not require each piece of the state's forensic evidence in and of itself to prove guilt beyond a reasonable doubt. The jury was presented with the cumulative effect of all the forensic evidence. The focus of this inquiry is not the outcome of the trial, but rather the reliability of the proceedings. And again, that comes from Thiel. Okay, so what she's all saying here, which I think is pretty straightforward, but in case you didn't understand, what she's saying is that when you have an evidentiary hearing, that is the place where you are debating the facts, and that's where you are debating whether certain things should be allowed or not. Okay. And what the Court of Appeals did is they were essentially saying that the testimony of the experts was insufficient to be able to state with any certainty anything about the facts pertaining to the blood, bullet, and bones. And so what Kathleen is saying is that they did not have the right to do that. That is not their role. They are not a fact-finding court. They have said it repeatedly that they are not a fact-finding court. So why are they drawing conclusions that should be made during an evidentiary hearing? You have the hearing so that you can put those experts up and they can give you more detailed conclusions on what they found. They can be cross-examined. They can do all of that stuff that will determine ultimately for the court what the actual facts are when it comes to these witnesses, to these experts. The court here is taking the experts just at face value, what they said, and that's it, and not allowing any other room for inquiry, to question things, to do, other things could come up. And Kathleen is basically saying, since when does somebody have to present their entire case and prove everything in a petition? That's the whole point of why you have a hearing. And that's why, in general, hearings are supposed to be granted. It is not supposed to be a one-stop, we're going to present everything we have and we're going to prove it all as fact and we're going to win our case on just the petition alone. You're not meant to have to do that. And that is what Kathleen is saying. She's saying, for some reason, why is it that Steve was supposed to essentially solve his own case and fix everything in just a petition? Why wasn't he granted a hearing so that we can flesh all this out and get more information? So then Kathleen goes on to say, Halbach's DNA was only found on FL. The Court of Appeals claimed, but the state did not argue that this specific bullet entered Halbach's skull or killed her. This is demonstrably false because of the state's expert testimony that the DNA on FL was the result of FL going through Halbach's brain. The Court of Appeals made another egregious error when it found that there is nothing to suggest that shots fired into Halbach's skull were the only shots fired at her, or that every bullet fired at her contained skull fragments. There were, after all, 11 casings and only 2 bullets found in the garage. And then she says it failed to recognize that the 11 spent shell casings in Avery's garage were never forensically linked to FL or FK or any bullet in this case. Dr. Eisenberg testified that there was no evidence of other gunshot wounds to the bones from other parts of Halbach's body. The court's blatant misstatement of facts about the cause of death of Halbach undermines the integrity of its opinion. And then she says, see Broomfield versus Kane, and I'll talk about that in a minute. And this is what we were talking about when it first came out and everybody was saying, but what about these factual errors? And I said that most of the time they will be found as harmless errors. And so essentially she's kind of just preempting that and saying, this is why I'm going to tell you why they are not harmless. That's why she's got an opportunity to address this. And she's saying, because she knows that's what they're going to try to say. And she's going to say, these are not harmless because you did not pay attention to the record. If you want to go by what happened in the court, which we talked about, I talked about legal facts and how the court is only going to go with what's on the record. And she's saying, well, if you're going to do that, then you have to actually pay attention to the record and make sure you have all your facts straight. And what you're saying is factually incorrect because that is not what they was said in court. And that's not what happened in court. So she's calling them out on essentially not thoroughly examining the entire record. And not only that, but they were drawing conclusions where they clearly weren't fully investigating all the background of those conclusions that they were drawing. If that makes sense. Am I making sense? I hope so. And then she goes on to say, when a lower court's analysis begins to weigh the evidence, and then she puts a parentheses, it misstates, and the contradicted facts a movement asserts are not taken as true, the need for an evidentiary hearing is apparent. So that's what she's saying. She's saying that it's misstating the evidence, and it's also weighing the evidence, and it's weighing uncontradicted facts, and it shouldn't be doing that. That's why you need to have a hearing. And she cited Pruitt versus Neal. Okay, so now the news that nobody's going to love to hear from me. I actually don't like that she cited these two cases at all. Brumfield and Pruitt are both EDPA cases. Brumfield was actually cited in Brendan's case. Okay. And these are specifically two cases that are EDPA cases talking about how it's drawing conclusions about facts that essentially aren't in evidence is what she's saying. But I said they're both EDPA cases, which are very specific. These are both cases that talk about mental disabilities, and it's very specific to a totally different situation. So I get what she's doing here, but when I looked at those cases, those aren't really the main conclusions you draw from those cases. Okay. So I'm just putting that out there. Yeah, they're both EDPA cases involving facts surrounding mental disabilities. And that's specifically what it's talking about. So she's trying to make it fit. And that's fine. I have no problem with her doing it. I just would say that overall, they're not the strongest citations in this document for that reason. And this is when I decided I'm not doing this anymore in this petition because that was too much work. My brain was really upset with me. So, so that's the only thing that I would say as kind of a on that one, is that I totally get what she's saying, and she's very right when she's talking about they don't have the right to make these factual determinations. That's what a hearing is for. She is completely spot on. I just don't love those actual citations, because again, when it comes to EDPA cases, they are very specific about what they're dealing with. And I mean, and you know how seriously they take that whole thing about you have to determine that the facts didn't support the case or whatever, because clearly they didn't believe that in Brennan's case. Because we all know that nothing in factual in that confession was supported by anything that was actually in the investigation, but they didn't see it that way. So again, that's why I say it's like I hate using EDPA cases, because there's just, I don't know. I say EDPA. That's why. I need a drink. Sorry. I should be drinking water. I know. Ugh. Okay, so are there any questions before I continue? Because I'm moving on to the second claim now. We don't really have that many people. We have 50, but usually we have a little bit more, but hopefully. Yeah, Michelle, I'm going to put that up there. I agree. Ugh, hate it. Hate everything about it. And no, Ronald is saying that, yeah, this is also just to make everybody aware, just like Brendan's case, if they deny review, they will not give us a reason. We will not have any idea why. How strong do I think it is? I think it's very strong for what she needed to do. I think that the standard by the Supreme Court is very high. Again, just look at it from what we worked with Brendan's case, how it seemed just by common sense, by everything that we knew, it seemed like that case should have been reviewed. I mean, like I said, we have all the social science telling us about false confessions. We know so much more. A juvenile case had been heard in 50 years. There were so many reasons why they should have taken that case, and they didn't. So I just want people to keep in mind that, again, it's always a long shot, but she did very good with what she needed to do, because she's focusing on the case law where she's saying that this needs to be addressed again. And she does this the most, I think, under the Brady claim. And I really like the Brady claim, because I don't know if it's going to go anywhere. But I since the beginning, I've kind of always liked this whole area she's going with the Weyerski ruling, because that was a big deal. When the Weyerski rulings came out, that was a big deal with regards to Brady material. And who carries the burden of having to supply Brady material? And right now, the onus has mostly been on the defendant and the defendant's trial counsel. And they've always used the saying that they have to exercise due diligence and prove that they couldn't have been found, that information could not have been found if they had, again, exercised their due diligence when investigating the case. That, again, is a really high standard. And Weyerski is the first ruling that took some of that burden off of the defendant and put it onto the prosecutor, and said that a prosecutor has to be held accountable as well. You cannot put so much of the burden on the defendant, especially when there are going to be many times where the defendant has no idea what they should be looking for. They can't ask for something they don't know about. So essentially what Kathleen is doing with this Brady claim, and she goes through a lot of it, but bottom line is she's telling them, you need to take this case because you need to explain exactly how much of the burden is on the defendant and how much is on prosecution. Because in Weyerski, you said that the prosecution has to take more of the burden. But now in this ruling, they're essentially saying that all the things Kratz did was not his responsibility. It was the defense's responsibility. So she's saying, okay, well, you made this ruling in Weyerski. Well, now you need to expand on it, because clearly it's not that cut and dry. And what she's doing is she's just trying to give them a reason under their criteria for having to explain, expand, create, whatever. She's trying to give them a reason to have to review the case. So that's what she's doing. And so let's see. so essentially the question she's asking them is the court going to stand by Wierski ruling, the Wierski ruling, which puts the burden on the prosecution, or not? Because there's confusion now. And anytime there's confusion over case law, that's when they have to review. So that's what she's trying to get them to do. Okay, so here's some of the things from here that she pointed out. The Court of Appeals did not consider the fact that Bobby himself testified that he was the only person from 6:30 to 2:30 that day, the relevant time period of the searches. So this is again going back to her saying that they were drawing conclusions and they weren't actually reviewing all of the record, because they were saying that they don't explain how they knew. The only person saying that Bobby was home that day was the person who was doing the expert that was doing the CD, reading the CD, and he would have no way of knowing that. And this is where Kathleen's like, "Are you kidding me? Did you miss the whole part where Bobby Dassey testified in court that he was the only one that was home?" So you can tell she's just really being like, are you serious right now? Like, how can you say that there's nothing showing that he was home alone when he actually said it, which is the most important thing. They are supposed to look at testimony, and they didn't. And so, yeah, she's really irritated. And she's like, you're making conclusions that are not backed by the record, or you're saying that we are not providing you with enough information that is already in the record and you should know. So, yeah, she's getting really irritated with them, and she should, because that is dumb. I mean, that's plain dumb for them to say, well, there's nothing showing he was home alone, other than his own testimony. That doesn't count now. It's like picking and choosing which legal facts, you want to pay attention to. And obviously they didn't want to pay attention to actual testimony, because they ignored Eisenberg's testimony and they ignored Bobby's testimony when drawing these conclusions. And then she says the evidence could have established motive for trial counsel's Denny motion, which the trial court found was the missing element. In 2019, this court articulated that any diligence requirement on the defense contravenes Brady and Supreme Court precedent, but in addressing Mr. Avery's Brady claim on the suppression of the CD, both lower courts agreed that trial counsel failed to exercise diligence. The Court of Appeals imposed a burden on the defense to generate its own report and analysis of raw computer data. However, given Wierski, the pertinent consideration should be whether the material of which the prosecution had possession, not to close to the defense, has evidentiary value, not whether the defense could have sought it itself. So this is where she's quoting, it's actually quoting Banks versus Dredke, which I have not read. But it talks about, it's quoting Banks, where it says, a rule thus declaring prosecutor may hide, defendant must seek, is not tenable in a system constitutionally bound to accord defendants due process. So again, that's kind of a long-winded say of saying that, how can you say my client got due process when this other ruling says that that this whole prosecutor can hide it and the defense must find it is not constitutional. It's not, it is denying them due process. They're saying that in that ruling, and they brought it up again in Wierski. And in Wierski, they're saying that you have to ask yourself whether it had evidentiary value. And if it did, they had no right to withhold it. That burden should not be on the defense. And so what they're saying is that they had this report. Just because they gave the defense attorneys or trial attorneys these DVDs, that doesn't mean that they weren't required to give this report that they generated, because that in itself was still evidence. And then she brings up the fact again, obviously, that Kratz lied about what was on it. I think that's in my notes here somewhere. I kind of have everything in a mess, but let me see. And then she calls them out for bringing up a bad citation, which is kind of what, I've been doing sometimes with her and the state and everybody else. She's calling out a bad citation. She's saying the Court of Appeals relied upon McGinnis for the proposition that Brady does not apply to secondary compilations or analysis of such. So that's where they're trying to say that just because the state used that same information and generated their own report, Brady doesn't apply to that report because it's considered a secondary analysis. And then she goes on to say McGinnis has nothing to do with secondary compilations and pertains to the knowledge a defendant would have about whether he took bribes. I haven't read the case, but So she's saying that that case citation is crap. So I didn't read enough of it to know if it's crap, but she's calling him out for it. And then she's saying the prosecutor misled trial counsel in 3 significant ways: that all the disks it had were disclosed, that the computer was Brendan's, and that the analysis of the data was of no evidentiary value. And then she's saying that what she's saying is that since Steve's expert did say there was unique information, but the Court of Appeals is saying that there wasn't, they are essentially saying that Steve's expert isn't credible, and claims of credibility are for the circuit court to decide. And so that's again where she's pointing out that they are overstepping their bounds. They're doing the work of the circuit court. That's the exact point, or that reason why you have an evidentiary hearing, is to establish credibility when you have conflicting accounts. That's exactly what they're supposed to do. Now, from a legal standpoint, I'm not going to lie, this is reaching a bit. It is. It doesn't sound like it because it sounds really good, but you do have to make some inferences there. And that's the only reason why we don't like when the court says they make inferences. And she's saying, well, essentially, by saying that it didn't have unique information, what you're saying is that Steve's expert's a liar or he's not credible. Well, they're not actually saying that. She's inferring that. And that's why I said that it's a little bit of a reach, but you can see it. You can make that an educated conclusion. But again, anytime you're inferring something that's not put down on the paper, it's usually not going to end up helping much, but we'll see what they do with it. But she's right as far as a part is that they are deciding things that really are just begging for an evidentiary hearing. And there's an overall sense of frustration of, like, she's really trying to kind of hit home here that, my God, he's only asking for a hearing. You are not deciding whether he's going to be out on the streets. This is for a hearing, something that is supposed to be granted in almost all situations. And yet you're denying him this. Like, why are you working so hard to deny him a hearing? If he has a hearing and you think all of this, then that's fine. We have to live with that. But you won't even give him a hearing. And that's where she's really that's the undertone of this whole thing, where it's like, are you guys really kidding me right now that you are just fighting this hard against a hearing? And then she actually says, like, what are you so afraid of? Like if we have another hearing and this all sorts out the same way, then that's fine. But for some reason, it seems like you are actively trying to not allow him to have a hearing. And that's a problem. Let me see what my notes don't even make sense to me. Let's say Stacy's saying Jerry Buting tweeted earlier that only 3 out of the 7 justices to get a review. Yeah, it's similar to the Supreme Court, and that it's less than half that you need. Let me see. Oh, and then she's saying that how they mischaracterized the comment about it not having evidentiary value as an off-the-cuff description. She says the court unreasonably determined that the state's representation in its stipulation projection was merely an off-the-cuff description of disclosed evidence. No reasonable trial counsel would consider the state's written remarks merely casual. The state's misrepresentation was anything but off the cuff, since it was explicitly written in the prosecutor's prepared stipulation, a legally significant document. Mr. Avery's trial counsel provided an affidavit concerning the state's non-disclosure of the CD, which the Court of Appeals also failed to consider. And that's when they were saying, like, well, obviously, if they had not been told there was no evidentiary value on it, then if they'd known that there was a bunch of murder porn on it, well, clearly they would have looked at it. But the way it was presented to them, and I am always still going to put this on Jerry and Dean. Sorry, I am. You don't believe a prosecutor, period. But this is what she has to work with. So that's the argument she's going to make. And this is why she's trying to get them here. This next part, she says this is how she's trying to get them to take the case that I was talking about before, when she's trying to find the right word and the right way to put it so that they're going to feel like they have to take the case. This court should clarify for the lower courts that Brady encompasses the suppression of a forensic report just as much as any other form of evidence containing facts that are impeaching or exculpatory. And she's actually putting it in the negative because she's saying that, well, then you should clarify for everybody that this doesn't count, that you're not allowed to get this. So she's actually putting it in the negative when she's saying this court should clarify for all the lower courts that the Brady encompasses the suppression. You're allowing them to suppress forensic reports. Like I said, she's putting it in a very negative tone, which is actually kind of funny to me. Because she's trying to really hammer it that like, this is wrong. This is not okay. You can't do this. All right. So then on the third claim, I'm trying not to be here all night for once. The third claim is that the Court of Appeals erred in affirming the circuit court's decision because its decision contravenes Wisconsin law on preservation of evidence, because there is no remedy for a violation in the relevant statute. This court should address whether the state's violation of the statute on preservation of certain evidence satisfies the bad faith requirement of Youngblood, and in turn warrants an evidentiary hearing for Mr. Avery. Now, this was a very different approach. We're all screaming about, I was even thinking, like, I thought one of the reasons they could hear it was because clearly Arizona versus Youngblood does not give enough explanation as to what constitutes bad faith, or doesn't really completely encompass like this type of situation. So she's actually doing the same thing, but she's doing it within the rules of the state statute. Because if you remember, the Court of Appeals basically disregarded the statute completely because they said that a 97406 petition has to be brought forth on constitutional claims only. And the constitutional claim of preservation of evidence was under Arizona versus Youngblood. Okay. So Kathleen is kind of twisting that a little bit, and she's saying, okay, fine, but what about this statute then? Because the court's job is still to clarify any confusion in the state statutes. And since there's no remedy listed, she's saying, so what exactly is the recourse if they violated the statute? And then she's trying to get them to apply it within Youngblood, because she's trying to get that bad faith component and then tie it to Youngblood, which would then tie it to it being a constitutional claim. And she's doing this through the Wisconsin state constitution. So again, she's bringing the Constitution in it. And it says that she cites Collins versus Lilly, and that's Lilly as in the pharmaceutical company, Eli Lilly. And she's saying the Wisconsin Constitution requires statutes to provide a remedy for their violation. As such, this court has been clear. Wisconsin courts have the authority to fashion a remedy for remedy-less statutes. And then she cites Collins versus Lilly. I went to look at that because I was very curious about this. And this is more of what it says in Lilly. It says Article 1, Section 9 of the Wisconsin Constitution provides, in part, that every person is entitled to a certain remedy in the laws for all injuries or wrongs which he may receive in his person, property, or character. We have interpreted this provision of the Constitution in the following manner. When an adequate remedy or forum does not exist to resolve disputes or provide due process, the courts under the Wisconsin Constitution can fashion an adequate remedy. Again, so this is how she's fashioning this into a constitutional issue, because they were trying to dismiss it as not being a constitutional issue. So she's bringing it back to the Constitution by saying, well, it becomes a constitutional issue when there's no remedy, and that remedy is denying Stephen Avery of due process. Then it becomes a constitutional issue, and you have the constitutional authority to provide a remedy. And the remedy she wants is that just by nature of going against the statute and destroying evidence, which could be potentially exculpatory, that demonstrates bad faith. And that's what she's trying to get them to say. Whether they're going to say that or not is a stretch, but she's not wrong that there's no remedy. So we'll see. Now, I can tell you right now, I can't guarantee it, but I can certainly see the state using that as an argument. Sorry, I didn't even say what it was yet. It was in my head. Sorry. State using as an argument that this is a job for the legislature. Because usually when it comes to state statutes, they're enacted into law by legislature, usually. But the court does have that power. And in this actual response, in this case, Collins versus Lilly, they actually did bring that up. The opposing side did say that this was a job for the legislature, which was funny because it was the first thing I thought when I read it. And they actually put in here, the court said, we disagree with this argument. It is the function of this court to modify the existing common law if that becomes necessary to promote justice under the law. So state can't really use that argument if they actually read the case, because they're just going to get the same response, but they're going to try to say that. Now, the only thing about Collins versus Lilly is that was a tort case. So there's nothing really specifying whether that precedent is also going to apply to a criminal case like this. But we'll see. We'll have to see what they do with it, if they do anything with it. And again, it's very unfortunate, but if they don't grant review, they can just deny it with no reason whatsoever, because I would really love to know the reasons. How do we learn anything if we don't know the reasons? It's very frustrating in that respect. And they can provide reasoning if they want to, but they usually don't, because they don't want to bother. Sapricop saying the legislature made the law. What more would they expect the legislature to do? And in most cases, people would say, I don't know, provide a remedy. Like, why do you make something a state statute and create a law and then not provide any remedy if somebody breaks that law? It makes no sense. But the truth is they didn't do that. So now somebody has to, and that's going to have to be the courts, unless somebody wants to revise the law. And who's going to do that? Because that law actually is for people who are in prison. And that's why nobody's going to want to revise it. Because it's going to help people that are in prison. And they don't want that. And then let's see what else she says about this. She says, now she's going, I think, more specifically into the bones themselves. And I am surprised. I'm not surprised, because my brain's stupid right now. That I actually this didn't occur to me. And I admit it. I was dumb. I didn't even think about this. But she talks about the fact that, here, I'll just read it. A previously undisclosed police report documents that these bones were held out to the victim's family as being the victim's bones. The Court of Appeals erroneously focused only on the testimony of the state's forensic anthropologist, confining its analysis to the suspected human bone fragment labeled 8675, the only bones from the gravel pit introduced at trial. The court ignored entirely Dr. Eisenberg's reports, which described numerous other human bones found in the gravel pit. Therefore, it erroneously concluded that the bones given to the Hallback family were simply of indeterminate origin. Okay, so that's not the part I was talking about. I mean, that was obviously going back to what we were talking about with Bobby Dassey. It's like they were ignoring actual trial testimony that was supporting Steve's claims. But then she says, the Court of Appeals overlooked that Mr. Avery was found not guilty of mutilation of a corpse. And I'm thinking, like, why did that not jump into my head when we were talking about it? Because it should have. It would have probably 3 years ago, before my brain went dumb. This gross misunderstanding of the facts caused the Court of Appeals to start from a premise not supported by the record that Mr. Avery is responsible for taking the bones to the gravel pit. And it's true. Steve is not responsible for those bones in any way legally, because he was acquitted of mutilating the corpse. So he's not really responsible for those bones in his pit. The bone fragments in the Dassey burn barrel, and then she makes a point to make sure to correct them, not Mr. Avery's, as the Court of Appeals incorrectly stated, and the gravel pit pelvic bone tagged under evidence tag 8675 had similar kerf marks, suggesting they came from the same source and underwent the same destruction or mutilation. So again, she's trying to tie it to the fact that Steve was acquitted of this, and yet those bones have similar markings. So if Steve didn't do it, clearly somebody else did, and that means whoever did it, throw the bones in the pit, could have possibly, had the bones out in the quarry, or dealt with the bones in the quarry. So, yeah, this is a very interesting take, because she is right when she's saying like Steve's not responsible for those bones. Everybody, because the case is so like tied together with everything with the bones and everything, it's easy to forget that he was not convicted of rape and he was not convicted of mutilating the corpse. He was convicted of killing her. That's it. Anything outside of that is not Steve's responsibility, not legally, not in any way. So yeah, it's very interesting that the Court of Appeals right away was like, well, Mr. Avery could have just taken the bones and dumped them in the quarry. And we're like, and Casey was like, whoa, hold on. Like, he wasn't responsible for anything with those bones. The court proved that, or the jury agreed with that at least. So how can you say that he could have done that? So it's a very interesting argument. And I give Casey a hard time when I think she's like not correct about things. And I certainly am going to give credit where credit was due. I think she did everything she needed to do in this petition. I think she very much focused on the mistakes, which is what she needed to do. I think she very much focused on the reasoning as to why this needs to be reviewed, what needs to happen, or like what they, why it needs to be reviewed and what needs to change for this to make sense. I think she did everything good. I said, other than not really loving a couple of the citations she used, that's really the only thing that and even then I don't have a problem with it. It just, I don't think it'll carry much weight. But I think she did everything she needed to do in this petition. Now, all that being said, again, it's a long shot. It really is. And yes, she only needs 3 of 7 justices, but I mean, you never know. Right now, the state doesn't want to deal with this case. So, and if this fails and they deny review, then Kathleen can file another petition for post-conviction relief and start over with some of the new the eyewitness stuff and whatever else. There's one thing I wanted to touch on. One thing we've talked about before I wrap up, the one thing we've talked about a lot was that Kathleen tried to get a new judge in the middle of the proceedings, which I was like, why did she do that? It's not allowed. And it's not allowed. And it was very clear that they said that, you know, the circumstances under which she can substitute a judge. And I have said, I'm like, yeah, once this case is over or this appeal is over, she can get a new judge. And then I was thinking about it. And I was like, it's not really that cut and dried. I would think they will let her have a new judge. But under the statute that she cited last time, the one that they were addressing, that does not allow for a substituted judge under this situation. And I'll tell you why. Let me see where it's at here. Okay, so she was filing it under 801-587, which says, if upon an appeal from a judgment or order, the appellate court orders a new trial or reverses or modifies the judgment or order as to any or all the parties in a manner such that further proceedings in the trial court are necessary, any party may file a request within 20 days after the filing of the remitter in the trial court, whether or not to, you can request a new judge. I'm not reading the rest of that. Okay, so what that's saying and why it was important before was that we were counting on there being a hearing. If there was a hearing and they sent it back, she could get a new judge. Under this circumstance, it says, if the appellate court orders a new trial or reverses or modifies the judgment, they did none of those things. They denied it. They did not modify the judgment. They did not order a hearing. They did not do anything. So I'm just putting that out there so that people know. And I don't really know, because technically you are only supposed to get one time that you'd be able to change judges. He's done it a couple times now. That's the only allowance they make, is for that if it comes back from the appellate court and they reverse or modify the judgment or they overturn the conviction, then you can get a new judge. So I really hope she can still get a new judge. I think that they'd be stupid to not allow it at this point, just because there's just so many questions of impropriety. Let's bring a new judge in. But I don't want to say that it's a done deal under statute, because it's not. So I just want to keep that, put that out there so people aren't completely shocked if something happens. But I mean, I still think she should be allowed to, and she's going to request it for sure. Absolutely, without a doubt. You guys are talking about Loof, and I don't know what you're talking about. You're having an entire different conversation here. And I have no idea what you're talking about. Does anybody else have any questions? don't even know what you guys are talking about. Should I read and try to see? And again, for those people just joining me, I did talk to Steve earlier today. He's doing good. He's feeling very hopeful. And as I know, I have like a lot more people that joined in. He's feeling much better. He's feeling hopeful. He thinks this is just a tiny little bump. He said he's had worse bumps in the road before. And he actually exclaimed that, I'm getting out of here. I am getting out. So, but he's in a really good mood. And that's good. He's very upbeat and he's very positive, and he still knows he has a lot of options yet. Of what can happen from here on out. So that's really good. I want to make sure everybody is aware of that. You don't have to apologize, Jinx. That's fine. I just was so confused. I didn't know what everybody was talking about. Why didn't KZ file a motion for reconsideration? Probably because they never work. I mean, you're essentially asking the same court to second guess themselves, and it's usually just a waste of time, and it would delay everything to have to petition the Supreme Court. So she probably figured it just wasn't worth the delay to try to do it when it really had no chance of succeeding. She just would rather try her chances with a different court. I'm assuming that's what it was, because they're not gonna change anything. Motions for reconsideration rarely do anything. You're better off trying to get a new judge or someone else to take pity on you and look at your trial, or look at your case. I mean, the 9/21 date, that is when the state has to respond. The state has 14 days to respond, and that's that date. So that's why that is on there. How long before we know anything? Well, again, the state has 14 days to respond. And then after that, the Supreme Court does not have a time limit. They can decide whenever they're ready, but this isn't something they're going to want to keep on their books long. So we're not looking at months. I mean, I think they would decide it relatively. Well, I guess I shouldn't say, because I don't really know, but there is no timeline, but I would think that it wouldn't take that long. Personally, I think they'd just want to get it out of the way. They don't have, I don't believe the state Supreme Court is as structured as the federal Supreme Court with their conferences and things like that. I think they are on the calendar, but it's not as easy to follow a case in the state Supreme Court as it is in the federal court. But I'll try and see what I can find. I know they have calendars that show their conferences, but I don't know if they list which cases they're talking about. Like, you could actually very closely follow what was going on with Brendan's case in the federal court. By the end of the year, I hope so. Yeah, it should be before the end of the year. I can't imagine they would take that long to dispose of it. What did Buting say? Buting said the court will decide by year's end. Yeah, that's what I said. I don't think it'll go into the next new year. I would hope it wouldn't take any longer than that. And I don't think it will take very long for Kathleen to file a state petition once that's done. I think she's pretty good to go on what she wants to do there. You can't imagine. You can't imagine the drivel and the response. Yeah, it's going to be. But you know what? They keep winning. That's the frustrating part. Half of what they say is complete crap. I have seen terrible filings from the state, and yet they still win, because it really has nothing to do with that. It has nothing to do with how good they are. We're doing what they do. They're just so against Steve. But what is the strongest argument in this motion? Oh gosh, that's hard to say. Because I can make a case for all of them. I mean, I think she made a good case for all of them, but I would not say anything is a slam dunk. I do like challenging Wierski, and I do like challenging the statute and asking for a remedy on that, but I don't know if I can really say one is stronger than the other. My original thought was the bone issue was going to be the strongest issue, so maybe I'll just go with that, because that was what I originally felt overall, that the bone issue was the strongest argument for getting a hearing. Stacy, I'm just reading your comment. Did I miss any questions? I hope not. So I don't know if I really added anything versus what other people have been doing videos on. I hope so, but if I haven't, sorry. I apologize for just being substandard lately. I hope my brain gets better one day and I can do the things I want to do. And that's what was most frustrating to me was that, you know, there's been other things that have come out that I'm like, oh, I don't even want to read them. But being that this is all about law, I really wanted to read this. I was really looking forward to reading this, and I couldn't do it. Couldn't do it. I tried for hours yesterday, and all I got was to page 6, and I gave up. Thanks, guys. I appreciate it. All right. If there aren't any other questions, then I'm going to wrap it up. And for once, I didn't take that long. It's only a little over an hour. So that's pretty good for me. So everybody have a good night. And I will talk to you all soon, probably in 2 weeks when the state files their drivel that we can all laugh over. So everybody have a good night. Bye.